Lord, may I be permitted to mention one contempt application?
Yes, give it.
May I take a lordship leave to mention one matter? Lordship, this is a signed matter. I've also mentioned it
It's a
before.
contempt of this bench.
Yes, my lord. Arising out of violation of the order dated 4th March 2020.
This bench.
Of this bench, my lord.
Any day, next week.
Grateful.
Lordship, this is an assigned matter. Lordship, I've also mentioned it before, but Lordship, it has not come into the list. Lordship, I'm praying for inclusion. Lordship, there's urgency that there's a widow who is Lordship. The death benefit is on hold.
Next monthly list it will come. Include it in the monthly list.
Lordship, monthly list.
Yes. In August it will come. Yes.
May it please your lordship. May it please your lordships. This, my lords, is my application. I'm led by Mr. Ghosh on the virtual mode. My lord, this.
Yes, my lord. This is my application for substitution. My lord, one of the parties to the proceedings have died. My lord, the pleading 6 and 7 and at page 7 of my application.
Application number?
And 4, my
This
lord.
is and 4.
Oh.
Well, we were intimated of the death on 26th of July 24.
No. Is there a restoration pending?
Well, the restoration has been
Allowed.
allowed, my lord. There was a restoration application which was can 3. The restoration was allowed.
And 3, my lord.
It's a partition suit, my lord. We had to bring on record, my lord, heirs of the deceased.
Substitution.
May I beseech your lordship to permit me to file a written note of argument?
Ganga
I am for the respondent number 9 and 10.
There is another date. Please, my lord.
On the
No, that is-
substitution issue.
Yes, my lord. Not for substitution issue.
Then what written argument you want to file? We are taking up an application right now.
Please, my lords.
There is a can 1 also pending. What is can 1 for?
Lord, scan 1 is the
But
application and
stay
order.
petition. That was a stay petition, I believe.
4 is not available. Let them get the can, then we'll consider.
We'll do that, my lord. Lordship kindly keeps it for tomorrow. We'll take necessary steps in the department. My lord.
May it please, my lords. There are 2 other deaths which are to be recorded.
Huh?
Substitution of Ganga Banerjee must be replaced by one Maya Chatterjee. Maya Chatterjee also died last year. But on 13th of July, this year, respondent number 1 has expired. So both the substitutions will also be recorded.
So there is another can pending.
There has to be
No, my
another.
lord, we were not intimated of this death. We have just come to learn from my learned friend.
13th of July.
So we'll take
Petitioner's
steps.
elder brother. Petitioner's elder brother died on 30th.
My lord,
30th
we were,
July.
as advocates, we were not intimated. We'll take steps, my lord, to have it done.
So let all the cans be, all the substitutions be taken together.
Who has passed away? He is plaintiff
Mr.
or
Kajol Chatterjee.
no plaintiff or defendant?
For the defendant, first defendant. Defendant number 1, Kajol Chatterjee. On 13th of July,
In the
Maya Chatterjee last year.
Please, this is not the way everyone will start speaking at the same time. See, in the appeal, he is which party?
Lord, the respondent number 1.
Respondent.
Now, respondent number 1 is also this. You have. So we are informed. You are for?
I am from respondent number 8, Mr. Bashudev Mukherjee. May it please my lord, may it submit first. Mr. Bashudev Mukherjee is my father.
Respondent number 8.
Mr. Bashudev Mukherjee is my father.
Oh.
This is the personal matter. I will only speak if my lords allow.
You could not be appearing. You are not in person.
My father is paralyzed. I am representing my father.
You are expected to know the legal position.
Exactly. I will file a wakalatnama with another lawyer in that case. Or petitioner in person. In that case, I have to represent my father.
In person, you can do it, but you are not the person.
No, it's my
Father is
father.
not.
My father is paralyzed since 2018.
All sympathies for him, but the point is, you are a lawyer.
I am.
You
I-
can appear only professionally or in person. These are the two options to you.
My Lord allows I can appear as a counsel on behalf of my father. Otherwise, I cannot appear as an advocate on record.
How can you? Will it be a professional appearance?
No, I will be appointing a lawyer in that case.
That's why we are saying you know the legal position.
I will be appointing a professional lawyer in that case.
We are informed that the respondent number 1 has passed away.
They require service. May I just take Mr. Ghosh's leave and make one submission, my lord? The appeal is yet to be admitted, my lord. As of right now, they don't have a right of audience before the appeal is admitted, my lord. Kindly will not direct us to serve.
Yes.
No, but there was a
Obliged.
caveat pending. There was a caveat pending when it was filed, which is why services.
It is unless we.
Absolutely.
Yes.
Obliged, my
Great.
Much obliged. Much obliged.
Deeply obliged, my lord.
lord.
Number 2.
My lord.
Lordship, in person, my lord, and I did not receive any information. 2 weeks pass away, but the respondent did not submit the reply of the said application. So just now, my lord, I am old person and it's too difficult task for me to come in always. So sir, may kindly consider this matter. Jugal Kishore Mishra.
Lordship, Mrs. Chandrayalam is appearing on behalf of the respondent, staying for 2 weeks.
See, there is bereavement in the family of the lawyer. There is a bereavement in the lawyer's family. Therefore, she has not come.
Yes.
So that we have to accommodate. We are informed that M.S. Chandrayalam, who is to appear in the matter, is unable to.
Number 108.
Lordship, I'm led by Mr. Osin Jana.
He's not appearing today because of certain reasons. So I'm praying for 1 day accommodation. 1 day accommodation, Lordship.
Let us see. It was called yesterday also.
Yes, Lordship. He also mentioned
Appealing for
yesterday.
Porshab, state, there is a two appeal, my lord, two writ petitions, one by the Porshab, one by the state. Well, state is appearing. Porshab, that matter of Mr. Jana was appearing, my lord.
All right. He had told us that he may not be.
The only thing, my lord, let this retain its position, my lord.
Not today.
Tomorrow it will be taken.
Yes, yes. Tomorrow it will be taken up. This will be called tomorrow. 108 and then thereafter.
Number 110.
Giving
11.
See that.
Lord, this appeal relating to Group 7 matter, my lord. The appeal paper out of time 75 days delay. And but only ground is that the first certified copy which has been obtained by my client, that has been damaged by due to rain. My lord,
There is no. Could be in the back. Not there. After. You have filed the Vakalatnama.
no, my lord, my junior is filed Vakalatnama.
Filed by someone else. Someone else. Where is your Vakalatnama?
But the rule is that in the before the single bench, if of the advocate on record, if the Sami Maktar, in the appeal there is no requirement on the file and separate Bhokaladnama.
Where is that rule? Let us see. Show us which rule you are relying.
I am not ready to.
Tell us. We would like to know. At least I would like to know. Speaking for myself, I would like to know these provisions.
Your lordship kindly adjourn this matter. I will satisfy your lordship.
And because there is a note here, the defect that the learned advocate has
Defect
not
only for the
executed.
not filing of the Section 5 application. Subsequently, that has been filed.
We are saying there is a defect of a Kalatnama. You are saying no.
No, I'm sorry.
Tomorrow or Monday? When do you want?
No, Monday and Tuesday, I have some personal difficulty on the Wednesday.
As date. Based on give the date of Wednesday.
Grateful very much.
Don't have too many cases.
Number 112.
अगली बार अभ्यास किए थे
नहीं ठीक है होते रहते हैं इम्पोर्टेंट
Yes.
My lord, I'm for the petition, my lord. In this matter, respondent was enrolled in the year 1994 and discharged on 30th April 2020 after the completion of his tenure, my lord. My lord, AFT as per section, my lord, 14 subsection 5, the tribunal shall decide both the question of law and facts. We have raised all the points of law, but they failed to consider, my lord. Why I am submitting, my lord? Kindly see page 32 of this petition, my lord.
Yes, what is the point of law?
Point on the injury. He injured out of duty, my lord, not during the duty.
So first it is a question of fact, where he sustained the injury and at what time he sustained the injury.
Yes, my lord. Kindly see page 32.
He sustained the injury after evening roll call. He was going back to his quarter within the compound and precincts of the unit. Now that is the fact, not in dispute. So what
And
is
the-
the conclusion? Legally speaking, what should be the conclusion?
Yes, my lord. This is the self-inflicted injury, my lord.
Self-inflicted.
Inflicted injury.
Who has said it is self-inflicted? Where is this finding?
This is my lord. Court of inquiry, my lord. Page 41, my lord. Opinion of the court. Next page is type copy, my lord. काउंटर रिवेटिव कितने नंबर पे है? नहीं, काउंटर रिवेटिव हाँ.
ये घटना जिस अवस्था और जिस कारण में घटा, उस हालत के ऊपर
गोबर के ऊपर से स्लिप कर गया.
Nobody is saying it is self-inflicted. Who says it is self-inflicted? Self-inflicted means something else. There is no finding that it is self-inflicted.
There are two issues involved, my lord. First, my lord, whether he is on duty or not.
Yes.
Second, the injuries, there is some casual connection or not. I want to satisfy, my lord.
Casual connection, once it is considered that he is on duty, the casual connection is there. If it is not considered as being on duty, then there is no connection whatsoever.
My lord,
so there is only one issue, whether he will be considered as being on duty or not.
Yes, my lord. I am relying upon one apex court judgment.
Let us see.
Relevant page is, my lord, 13, my lord, of this judgment.
Jujhar Singh, we have seen in another case. He was on leave. He was at his village.
My lord, kindly see para 13, my lord, for my satisfaction, my lord.
Yes, correct.
The accident occurred at 4:15 p.m.
Yes.
While his duty shift was to commence at 4:30.
Yes.
Here is after the completion of his duty, he is returning, my lord.
A road accident may happen anywhere at any time, but such accident cannot be said to have arisen out of employment unless it is be shown that the employee was doing something incidental to his employment.
What is the provision in the pension rules?
I'm
While commuting from and to the,
referring, my lord.
in fact, he was not commuting, he was on duty, he was inside the,
From
what
the
is it, camp, what is it? Base, where this has happened?
Panagar
It's a base.
base.
Yes, where is a, shows the provision?
Yes, my lord. Graduate connection, duty. Kindly see page 150A. Type copy, my lord. I'm relying subpara A, my lord. When performing an official task, or a task failure to do would constitute an offense liable under the disciplinary code applicable to him. He is not performing any official task.
Yes.
Thereafter, subpara 5, my lord.
You are relying on?
9A and 9F.
9A, you are showing 10.
No, my lord. 9, page 150A.
9A. No, that's 149A.
One in respect of duty, my lord. When performing an official task,
This is pension rules.
Pensions rules, my lord, entitlement rules. Thereafter, I'm relying subparagraph F, page 150, 51A.
Subpara.
F. Death or injury which occurs when an individual is not strictly on duty, on leave, including cause of death or disability as a result of attack or shot against extremists or anti-social elements, may also be considered suitable to service, provided that it risk which was due to his belonging to anti-social that
You're reading F.
F. Same was not risk faced by the civilian death or disability due to personal entity is not admissible.
How this will apply?
Due to personal entity. Thereafter, my lord, come to same page, my lord, in respect of attributability injuries. I'm relying 10 Roman 2.
Nobody has said it is self-inflicted. When the fact is not there, how you can rely on this provision? Where is the finding that it is a self-inflicted injury? You can't say anything which is not there in the record. Unless there is a factual finding by any board that it is self-inflicted, how can you say it is self-inflicted? You can say it is suicide. What is this? In court, you can say anything, or you have to confine yourself to the finding which is returned by the board there. You have to confine yourself to the finding. What is the date of the order, tribunal's order?
18 June 2024, page 156.
You have given the benefit.
Huh?
You have given the benefit.
No, my lord. He is getting only service pension.
Yes, that we have seen.
We have raised all the issue in a position, but the learned armed forces tribunal did not consider single point of our opposition, my lord.
Yes. Where have you said in your opposition that it was self-inflicted? Show.
Yes, my lord. Huh? Hmm. We have never stated any self-inflicted injury, my lord, but kindly see page 81, reasons of
How
the
as an advocate, you make such submission when the fact is not there.
reason for the rejection, my lord. There is a tabular statement, tabular chart, my lord.
So 6 and 9 have been relied upon.
6 and 9, my lord.
Yes, sir.
But Honorable Tribunal did not consider this point, my lord, at any point of time. In para 13, we have stated, my lord.
Where is the court of inquiry?
This is the opinion of the court, my lord. Page 41. It starts from page 89.
Court of inquiry.
Court of inquiry.
What is page 41?
Opinion of the court of inquiry. Opinion of the court.
So that is relevant or 89 is relevant?
That is relevant, my lord.
89.
Right.
Very clear. It's after on a turning, we have stood on some cover. Or it could not control it. Motorcycle, we are sustainable. Second, but to be ground. Either in
State of affairs that you have filed a WS, and in the WS you have stated that it is self-inflicted. Neither the court of inquiry says so, nor the opinion of the court says so. This is how you treat your soldiers.
In remarks of the commanding officer, my lord,
Yeah.
it was page 92. Injury sustained by the individual in an accidental injury.
So accident means self-inflicted. We are trying to learn this, whether how to treat it as a self-inflicted. And who is this commandant to take such a decision? Who gives him the expertise to take such a decision? The decision is of the court of inquiry. That doesn't say so. So how the commandant can say anything like this? Sitting in his office, he will, based on the paper, he will say it is self-inflicted. Even he has not said it is self-inflicted. Very unfortunate, this case we are seeing. To resist the claim, you will take any ground in the court. which is not borne from the records also. And that also in respect of such a service. And we are looking at the records, everywhere you say is exemplary. And few months before his retirement, he suffers an injury, and then you resort to such a affidavit saying that it is self-inflicted. Everywhere we see about him, you have written exemplary performance. For such a person, at the end of his career, you will take such a ground. Yes, take down. The Union of India is the petitioner. 113.
Lordship, I'm for the respondent. Lordship, copy is yet to be served to us, Lordship.
We'll see the matter, then we'll see.
My lord, similar matter lots of fixed tagged with in this kindly see order. Similar matter has been tagged, my lord.
What is the issue?
In the entitlement rules, my lord.
No, what is the issue pending in these matters?
Dharamveer Singh case. Same issue, my lord.
This is pending.
Pending, my lord.
First give a copy, then we'll see.
I will undertake to give.
And Lordship, also there is a typographical error in the order sheet passed by the learned tribunal, Lordship. The date is actually the grant of disability pension is 28th February 2019.
Which page?
Actually, the order sheet also. But here it is wrongly typed as 29 February, Lordship. So
Date.
15th May of 2024. The order sheet passed by the
The
learned.
date of the order is wrong.
Yes, Lordship.
Instead of 15/5/24, there is it should
Not the date, Lordship.
Para 17.
Para 17.
17. There will be 28.
para 17 of the tribunal's order.
Yes, my lord.
Instead of 29, it should be 28.
28.
And
Because 19 is not the leap year, my lord.
Lordship, and accordingly, we have filed a modification application also. And
Before the tribunal.
yes, Lordship, and they were pleased to grant the same.
Already it has been done.
Huh.
So why is that order is not part of the record?
Not, my lord.
If it has been modified, you are required to place that order on record.
Then my leave may be granted to
Here-
file supplementary
We
evidence.
are informed that the order of the armed forces
That 14 and 115.
But it's the Union of India, both as petitioner and respondent are present, but the petitioner is not present.
Union of India on both sides. Why?
Because there are two applications. In one, they have filed, they have challenged the order. The applicant in the OA has challenged the order. In the second one, the Union of India has challenged the order.
115 is filed by you.
Yes.
For item number 115, I am appealing on behalf of Union of India.
Union of India. Oh,
Yes.
let us see your matter first.
What?
Why both have filed a writ petition?
My lord, if your lordship kindly sees the prayer, it has been summarized, my lord. Page
Affidavit in opposition.
Affidavit in opposition. In which case?
Item number 15, Lord.
You have served.
Copy service, Copy has not been served.
You serve, then you file it.
Service common.
Let's see 114. Yes.
In this matter, my lord, if your lordship kindly take that And we have challenged two orders, my lord. The impugn order, and thereafter a review was filed, my lord.
Impugn order is, what is the effect of the impugn order?
If all prayers has been denied, my lord, only one prayer has been allowed. The disability pension has been directed to be paid. My lord. He was not entitled to as per the rules, my lord. Subsequently, central government had modified the rules regarding broadbanding and also disability pension. Now, my lord, he was paid when this memo came into. He is seeking, the direction is for bringing him from the date of his original retirement. My lord.
So you are aggrieved by the retrospectivity of the order?
Yes.
That's all.
That's all.
So what is the?
Now this matter is again pending before the Honorable Supreme Court. There, my lord, an order has been passed to pay the order has been stayed. An order of the learned armed forces tribunal was challenged. If your lordship kindly takes up page 126. That order was stayed, but a direction was learned additional solicitor had given an undertaking that period of 3 years prior to date of filing of the original application, that will be paid, my lord. In this case, my lord, that is complied with.
So this is not there. There is no order insofar as.
No, this was the merits has not been.
No, it is in the case of this petition, that petitioner only.
No, this is being done in respect of all. This is being followed wherever the issue was, when will it take effect, my lord?
But there is no decision on that aspect.
No, no. That is not evident. The facts of the case are not evident from the
And
order.
it is to pay from 3 years prior to the order passed by the tribunal.
Yes, ma'am. So in this case, that is not an issue, but the issue is when from when it will take.
No, 3 years prior to filing of OA.
OA. Well, as per previous judgments of the Honorable Supreme Court, Tarsem Singh judgment, where it was limited to 3
order of 2018.
Yes, ma'am. It is still pending, possible. Pending.
This 18 matter is pending.
Yes, ma'am.
Where is the notification giving the benefit of which retrospectivity has been granted?
Well, one is 122, my lord. There are two parts. My lord, this is regarding broadband. 122. 9th February 2018. এখানে বলেছে না? 2016. Well, kindly see page at paragraph 7 at page 123. This is regarding broadbanding, my lord.
1/1/2016.
Yes, my lord.
And the tribunal has awarded allowed the claim with effect from which date?
From date is of his retirement, my lord, 2006. In similar cases, my lord, there is possibly, your lordship, in this case also, the order was passed without giving us any opportunity to file an affidavit in opposition. In some other matters, your lordship has stayed such orders, my lord.
No, have you taken such a ground in the writ petition?
My lord.
Have you taken this ground in the writ petition?
No. My lord, we have said that opportunity was not given, a review was preferred, my lord.
No, so therefore is this fact is borne from the record that no opportunity was given. In the review order must be recorded.
In the review, there was a delay of possibly 3 years or 4 years, my lord. That was also not considered earlier, my lord.
But
while
now,
passing the main order.
but
In
now the review order is there, so everything has been.
it has been condemned without saying what are. It has been saying that there are sufficient reasons.
Sufficient?
Sufficient reasons. With but the petition does not have any sufficient. Does not say anything.
And why the petitioner has challenged it?
there are three claims. If your lordship says takes up the impugned.
So for the remaining claim, he has challenged.
For the earlier, there were three claims were there, my lord. On the third, it has been allowed. Previous two has been denied because, my lord, he has been filing one after another applications before the Patna High Court, and those were rejected. First application was rejected, then second was rejected on the ground of res
After
judicata.
Patna High Court, why he has come here?
Well, boss, I do not know.
Kindly go through the
Patna High Court.
kindly go through the order dated 5th May 2024. Everything
Number 116.
My lord,
116, I am for the
sorry,
petitioner.
my lord. The Lordship has posted, my lord, 12 p.m. My lord. My lord, my lord, intimated to my lord senior, my lord. He sent me an SMS that he cannot come now at 12 and he can come tomorrow.
So you are one step forward from yesterday.
So, but otherwise, my matters are being infractions. I have been requesting my
Or
lord.
then if he is coming, then we'll take it up tomorrow.
But, if Lordship kindly just request, I just make your request to your Lordship. If it could be posted as
Want
top-
an indication?
Yes.
All right. Which are the matters?
12, 13 and 14.
Yes, give an indication in tomorrow's list at the top.
Great. I'm sorry, my lord, to disturb your Lordship again and
Well, in item number 116, I am for the petitioner, my lord, Mr. Bikash Ranjan Bhattacharya, senior advocate, appearing in the matter, my lord. My lord, kindly take the matter, my lord, after my lord 20th August. He will be available, my lord, after 20th August, my lord. From Friday, my lord, he will not be available. My lord, after 20th August, any day. I am just informed. The matter is very interesting matter. The petitioner matter seeking regularization. They are the lecturer of polytechnic colleges. They worked more than 10 years since 2008, and they are appointed in the post of sanction post. Now, Uma Devi, judgment of Uma Devi comes to play. Yes, I got it. Jaggar. Yes. I will judgment about Vikram Nath judgment. You are saying me. Yes. Jaggo versus Union of India. I brought it. Yes, my lord. Yes, absolutely. এই যে এটা নিয়ে আমি লিখে নিন দালি
Matter is adjourned to be taken up on 20.
Similar matter, my lord. 117 also similar.
Same order.
Obliged, my lord. Grateful. তুই লিখে নিয়েছিস তো ঠিক আছে
My lord, I am appearing, my lord, on behalf of the petitioner. For the file. কবে হয়েছিল মনে আছে? Doctor, and he was working as assistant professor, forensic medicine and toxicology in Shagor Datta Medical College and Hospital, where he joined on 6th December 2021. Within a span of 8 months, he was transferred to Jalpaiguri Medical College.
Yes, we have made a specific query. What
Yes,
is the
my lord.
Huh?
Number 35.
My lord, may I? One notification was placed before your lordships, but
Yes, 8322.
yes, my
We
lord.
had asked them to find out whether it is still on.
My lord, my humble prayer will be, firstly, till last Friday, it was not shown in the website. Number two, they did not place this notification before the tribunal. Suddenly, they are coming here and placing the notification before your lordships. But our case is completely different. Our case is I belong to West Bengal Medical Services cadre. My wife, she was of West Bengal General Services cadre, but she was a doctorate degree holder working as clinical psychologist. They did not rely upon that notification in the tribunal. And we prayed for reasoned
You
order.
have relied on 8322. 8322, you have placed reliance.
We have not relied. Now they are relying. My lord, kindly sees page 163. Kindly my lord comes to page 163. It volume 2 na volume 2 163. আমারটা কোথায়? Volume 2 কি দিচ্ছো? Volume 2 কোথায় page
163 will be in volume 1, not 2. Unless you are referring to something.
Yes, my lord. Annexure, মানে this is in the annex. আমার এটা তো ভলিউম 2, এটাতেই আছে। অ্যানেক্সে কোথায় আছে? কতটা বার করো। ভলিউম 2 তে কোথায় 163 কোথায়? ভলিউম 2 starts with 200 আমার পাতাটা My lord, volume 1 166. Sorry, my lord. Extremely sorry, my lord.
1, yes.
Volume 1 166. This was the clause G. Clause G, shall I read, my lord? They did not show the present notification before the tribunal. And my lord, our case was when we attended the hearing, they passed an order, but not a reasoned order. Just said, go and join. That is in page 97, volume 2. Order passed on 14th of August 2024. Thereafter, we went to tribunal. Tribunal initially appreciated our case, but they said, we cannot do anything, go and join. Page 97, volume 2. Page 97, volume 2. Eta holo order. There was no discussion. Kindly seize my lord page 97 once, volume 2. Volume 2, page 97. Why we are before your lordships? This order is not a recent order. তারপর হচ্ছে এই ভলিউম 2 এর 308 তো ভলিউম 2 এর 308 না এটা কত ভলিউম 2 308 কোন ভলিউমে ভলিউম 2 তে কোথায় পাচ্ছি না কেন আচ্ছা ও আচ্ছা 308 ইজ দ্য লাস্ট পেজ তো হ্যাঁ 308 এর পরে ওটা শুরু হচ্ছে ওকে ভেরি গুড
Impugned order is dated 4/4.
Yes, my lord, 4th of April 2025, just after page 308 of volume 2, and the certified copy starts. This is the tribunal's order. There also, my lord, my learned friend, she did not show that notification. Suddenly she is showing this notification before your lordship. So I am asking myself whether they are relying upon that. Then why they did not place that notification before the tribunal or before the authority where the hearing was taken place?
That question, does it have any significance if there is a provision and for some reason it could not be placed? That will not wipe out the provision. Things have to be proceed in accordance with the provision which prescribes a particular thing. So whether it applies or not, that is what has to be seen. Why they didn't place it, how is that relevant today? We are considering it.
My lord.
Let us see what is the effect of that provision.
My lord. Well, shall I hand over the copy of those notifications, my lord?
This is the 22
Yes, my
memorandum.
lord. Yes, 8th March 2022. Dada, ekটু দিয়ে দিন।
No, but the query that was required to be answered is it still in vogue at the time of issuance of the transfer? That is the query of the court in the last order. Probably after considering your submissions, there was a dispute whether this applies or still does not apply.
Yes, my lord.
So what is your response?
My lord, if we rely upon this, then also, my lord, I have one specific submission.
Yes.
My mother is sick, my lord, and here it is stated, এবার যেন কোথায় আছে যে মা যদি অসুস্থ হয়ে যায় মায়ের জন্য কোথায় যেন আছে
From where have you
7
from where have you been transferred and to which place?
Yes, my lord, I have been transferred from Sagor Datto Medical College, North 24 Parganas to Jalpaiguri. So Jalpaiguri. সাতটা দেখাবো তো parent of dependent female mentally handicapped. If we rely upon this, my lord, I shall place clause 7 only. Notification of March, 8th March. ওরা রিলাই করেনি কিন্তু এখন স্যার জিজ্ঞেস করছেন আমাদের রিপ্লাই কি আছে এটার ব্যাপারে আমরা কি
No, this is the clause 7, how it is relevant.
Well, I have stated before the tribunal as well as before your lordship that my mother is more than 80 years of age and she's seriously sick. My lord, my wife, she stays at Purulia.
No,
I am
this is for offspring, not for parents.
parent of dependent physically and mentally.
No, this is if the employee is a parent of dependent or physically, mentally handicapped offspring. This is for children.
My lord, B clause B, sorry, my lord.
Or if he is a legal guardian of such a person, then also that is not your case.
My lord, that was my submission also, man. That was my
No,
prayer.
but this does not apply for parents.
Legal guardian of the
This is
dependent
for
physically-
children and for if you are a guardian of such a person, not for a parent.
Or yes, my lord, for children.
For
But
children.
my lord, kindly appreciates our position, my lord. This was not, my lord, shown in the website also till last week. Well,
See,
how do
that
we
is
know, my lord?
immaterial. The point is, if it is a provision governing or a guideline for transfer, it has to be observed.
My lord, then my lord, my humble prayer will be kindly allow them to take another hearing and I shall appear before them. Then my lord, they could pass a reasoned order.
But you are not joining, you are not working there. That is the
My
disturbing
lord,
thing.
Initially I joined.
Yes.
Thereafter I filed my application
From
for-
October 22.
Yes, my lord. I was joined there on 26th of July 26th of July 2022. Thereafter আমি কি দিয়েছিলাম application দিয়েছিলাম sick application, leave application.
And you are a doctor.
Yes, my lord, doctor, my lord, of assistant professor forensic medicine and toxicology.
Appears it doesn't make any difference where they post you. You can stay away from work anyway.
My lord,
You can stay away for more than 2.5 years and still come to the court saying that let them consider
presently,
such a doctor whether we should.
my lord, I was before the, my lord, I was taking the shelter of law, my lord, either before the tribunal or before the honorable
That's
court.
why we are saying to you, it hardly makes any difference where you are posted. Your posting is immaterial. If you can stay away for such a long time.
I bow down before your lordship, my lord. I have filed leave applications. Thereafter, I went before the tribunals, and thereafter, I have come before your lordship.
So we understand and appreciate what you are saying, but then still the issue remains. Then it is at your wish. If you don't want to join, you will keep litigating.
At least
And
a
you
chance
are a
of
doctor,
hearing, my
you
lord.
owe some duty to the public also. If every doctor is to be accommodated as per his wife and parent, then
My lord,
the entire system will collapse.
we thought that we would get the advantage of that earlier policy. We did
But
not
that
know.
policy is not in
My lord,
existence.
that as this was not shown in the website, we did not know that another.
How will you know? You are not even attending your duties. You don't know what is going on in the department. You are absconding since 22.
My lord,
And this memorandum is
I
of
have-
22.
I have taken the shelter of law. This much, my lord.
Here you can do
At
that.
least a chance of, if a chance of hearing can
For
be given.
such person, we are not inclined. You joined and you served and immediately you left. For more than 2 months you were gone. They said you have still not joined. You said on 11/10 I will join. After that also you have not joined. So for you it hardly makes any difference where your posting is. There is the order which you assailed before the tribunal.
Yes, that is in
The director's order
paper
12/8/24.
12/8/24, page 97, volume 2, page 97 of volume 2.
Volume 2 is having a running page.
Sorry, man. না 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 আমাদের কিন্তু এসেই করলাম এই
At the end of volume 2.
14th অগস্টের অর্ডারটা এই বছরই বের করলাম ভলিউম 2 পেজ নাম্বার 97 ইন্টারনাল পেজ 97 of the certified copy. Volume 2 in I have annexed all the certified copies there in internal page 97. দু মাসের বেশি থাকেনি আর চলে এসেছে তাই না
What is your submission? What is the infirmity with the order?
Page 97.
14/8/24.
14th of August 2024.
Yes, they want you to join your duty.
Yes, my lord, but hours
which you have been away from since when? Since 7/8/22.
yes, my lord.
Immediately after joining at Jalpaiguri, you left. 7/8/22, nearly now 3 years. What consideration is to be accorded to you? You can stay away from work forever.
No, my lord.
Doesn't make a difference where your posting is.
Our humble prayer will be, my lord, at least a reasoned order could be
Such
passed.
medical officer, what reason order? Without
Well,
joining, why the court should hear you?
My lord, before
Public
that, I
service-
went to the tribunal and my lord, I referred the original application, that is OA 294 of 2004 in page 172. 172, volume 1 or 2? Volume 1 or 2, 172. Volume 1, 172. Hereafter, I'm taking your lordship to page 97, page 172. Yes, this is the order of the earlier original application. The prayer, I'm reading from the second paragraph. The prayer in this application is for setting aside the impugned order dated 26th of July 2022, by which the applicant was transferred to the post of assistant professor in Jalpaiguri Government Medical College to Purulia Medical College and Hospital. Though the applicant complied with such transfer order and joined the new post at Jalpaiguri, but continued to furnish representations before the respondent authorities seeking transfer to any post in any of the following districts: Purulia, Howrah, Hooghly. Mr. So-and-so, learned counsel appearing on behalf of the state respondents had submitted that though the applicant joined the new post in Jalpaiguri as per the transfer order on 29th of July 2022, but after joining, he remained absent till date. Several show-cause notices were issued to the applicant for his unauthorized absence, but neither did he resume his duty nor he replied to those notices. But my lord, I have furnished several representations. Third paragraph, having heard the submissions of the learned counsels of both sides and considering the facts and circumstances of this case, the tribunal leaves it to the discretion of the competent authority, the principal secretary of the Department of Health and Family Welfare, and taking a final decision in this matter. Though the tribunal has not gone into the merits of the matter, but on the very surface through submissions and records, it appears to the tribunal that the applicant has been requesting for a transfer to Purulia nearby places. His representations for transfer Purulia to join his wife, also a medical doctor, and with two minor children appears to be reasonable. While though tribunal did not enter into the merit, but this was fine that his prayer was reasonable. Let such considerations of his prayer be taken within 60 days. From the date of communication of this order, accordingly, this application is disposed of. Thereafter, I appeared before the hearing. Well, my humble submission will be that it was appeared as reasonable before the tribunal, but without showing any reasoned order, my application was rejected, only said, go and join. Kindly comes thereafter to page 97 of volume 2, wherein the certified copies were annexed. Internal page 97. Before the আচ্ছা ওখানেও তো ইয়েটা করেনি ওই নোটিফিকেশনটা দেখায়নি তো before the tribunal also on 18th of July 2024 they did not place that notification, but my lord, they only stated that I have not joined. Yes, I have not joined, but I have placed several representation and sought for transfer where my wife is also working. Tribunal stated that tribunal has not gone into the merits of the matter, but on the very surface, through submissions and records, it appears to the tribunal that the applicant has been requesting for a transfer to Purulia or nearby places. His representations for transfer to Purulia to join his wife as a medical doctor with two minor children appears to be reasonable. Here I am pausing for a moment and humbly submitting that had it been a case that they have showed this notification, then my lord, I would not have gone to the principal secretary. They did not place that notification also. তারপরের কথাটা হচ্ছে ইয়েটা কত লেটেস্ট এইটাই পেয়ে গেছি। ওহ, তুমি এমন ভাবে অ্যানেক্স করেছো না, জড়িয়ে পেয়েছি না। না আমি আর পরে জানলে হবে বলতে পারবো হ্যাঁ সেভাবে নতুন ঝামেলা না এটা জয়েন করছিল তখন সাবসিকুয়েন্ট অ্যাপ্লাই করেছিলাম জয়েন বলেছে কোনো ভ্যাকেন্সি টোয়েন্টি 21 ডিসেম্বর তাহলে 2.5 বছর পরে আর Now I shall take your lordships once again to page number 97, internal page 97.
Yes.
Of volume 2.
97.
97. I attended the hearing before the principal secretary and he passed an order on 14th of August. I'm only reading, my lord, kindly hear. Wherein in compliance with the order dated 18th of July 2024 of the Honorable WBAT in OA 294 of 2024 and OA 292 of 2024, Dr. Noreen Sarkar versus State of West Bengal and others. Dr. Noreen Sarkar was heard by the Principal Secretary, Government of West Bengal on 12th of August 2024 at 4:30 p.m. at his office chamber, Shastro Bhavan. Thereafter, the observation, Dr. Noreen Sarkar is hereby directed to report the Principal, Jalpaiguri Government Medical College, Jalpaiguri for his public duties immediately. Non-compliance of his order would be viewed seriously. This has the approval of competent authority of Health and Family Welfare Department, Government of West Bengal. Here I am pausing for a moment and my humble prayer will be, my lord, learned tribunal, my lord, observe that there are some reasons why I have gone over there. Here, without applying mind, without passing any reasoned order, he only said, go and join. Thereafter, my lord, yes. Hereafter, we went to the tribunal. After page number 308 of volume 2, I have annexed the tribunal order. Yes, yes. Shall I read that order, my lord?
Yep. 97.
97 I have placed.
Yes.
Now I shall take your lordships once again to the order impugned. After the order being passed in page 97, I again went to the tribunal. And tribunal passed an order on 4th of April 2025. That is in volume 2 after page number 308.
Yes.
Certified copy. I am reading, my lord. paragraph 2, in terms of a direction of this tribunal in OA 294 of 2024, dated 18th of July 2024, the Principal Secretary, Department of Health and Family Welfare, heard the applicant on 12th of August 2024. The tribunal, after considering his prayer in the earlier application for transfer to his choice of place, had directed the Principal Secretary, Department of Health and Family Welfare to take a final decision in the matter. By memo number 2059, dated 14th of August 2024, the Director of Medical Education, referring to such a hearing by the Principal Secretary on 12th of August 2024, directs him to report to Jalpaiguri Government Medical College as its assistant professor. Mrs. So-and-so, learned counsel, had argued that although the tribunal had directed the state respondents to consider his representation for transfer to Purulia, but the respondent authority, instead of considering such representation, transferred him to Jalpaiguri. Such action on part of the respondent authority was not in consonance with the view of this tribunal. Mr. Rai, learned counsel, had submitted that the applicant who was directed to join Jalpaiguri Government Medical College as the assistant professor joined his duties in his new place of posting on 29th of July 2022. But from 30th July 2022, he remained absent from his duties. Mrs. So-and-so argues that due to family reasons, the applicant could not continue his duties at Jalpaiguri and sought for leave by furnishing leave application. A copy of the leave application dated 7th of August 2022 shows he had prayed for leave on several days, which ended on 10th of October 2022. In the leave application, the applicant also informs that he shall be joining his duties on 11th of October 2022. Mrs. Bhattacharya submits that the applicant continued to be on leave after submitting such leave applications. The law relating to transfer of government employees is well settled. The Honorable Supreme Court, in its judgment in 2004, Volume 11, SCC 408, made it clear that the transfer is not only an incident inherent in the terms of for appointment, but also implicit as an essential condition of service. It is also the complete discretion to the competent authority to effect any changes in the manpower by way of transfer from one place to another. The applicant as an employee have prayed for transfer to selective places of his choice, but it has to be appreciated that choice of posting in a particular place or places are to be in tune with the administrative convenience. Keeping the larger interest of public health, a medical personnel can be transferred and it's obligatory on his part to comply. The Honorable Supreme Court also advised that transfer matters should be normally eschewed and should not be countenanced by the courts or tribunal. Thereafter, in the light of the above judgment of the Honorable Apex Court, this tribunal declines to interfere in this matter. Thereafter, my lord, on the basis of the earlier notification, I have filed this matter. But my lord, we did not know that subsequently another notification has been issued. But my lord, our case will be, they also did not rely upon that notification. Probably they also did not know. Hence, my lord, we have got no opportunity of submitting anything upon that notification in the either before the principal secretary or before the learned tribunals. This is my case, my lord.
Two aspects of the matter. Aspect is that he is pursuing the department for a posting as well. It's not a case of any transfer being challenged. Challenge being transferred of his choice. Seeking a posting of his choice, he is absent from his last 3 months. Thus, a circumstance should exercise a suitable jurisdiction to interpret this level to trade, which otherwise also is not suffering from. That judgment.
But this is my case, my lord. My humble prayer will be, my lord, if I can be, my lord, again, I can be receive the chance of proper hearing, my lord.
Not for such a doctor. We are not inclined. 3 years staying away from public service, we are not
Now,
at
my
all
lord-
inclined to entertain any plea on your behalf.
My lord, my humble another submission, my lord. In the month of December, I wrote.
You have to choose whether your personal needs are more important or your job is also important.
My
That
lord,
is
my
for
lord,
you to
kindly
decide.
appreciate one thing. Subsequently, I preferred one.
You keep doing whatever you want.
No, my lord.
What is, sir? The issue is, what is your right to be enforced by issuance of a direction? Tell us.
Yes, my lord. I bow down, but my lord, at
You
the
have
same
no
time,
right.
now, my lord, I am
There is no
suffering.
transfer order under challenge. You want that a direction should be given to post you. Is there any such enforceable right in law? Tell us, show us one judgment. It's an impossible situation for you. You have to, if you don't want to join, you stay away,
My
you will
lord,
suffer the
now I am
consequences.
facing
What
another
can be?
difficulty? I write a letter
You are
under
not facing any
Right to
difficulty.
Information Act to join at
See, at least
Jalpaiguri. Now, my lord, they have taken someone else in my place.
I don't,
Now, my lord, I am asking myself what to do.
we don't,
Where shall I join?
it is good for you. You don't want to join anyway. You have not been joining for 3 years. Public service means nothing to you. That is the info, that is the impression we are gathering. Such a person, 3 years. What is this? We don't know why nobody has taken any action against you for 3 years. But we don't want to say anything on that. We don't want to say anything on that. Yes, heard learned counsel for the petitioner. Stop. The petitioner.
For order, item number 3.
WPCT 93 of 2023. WPCT 93 of 2023.
Yes, sir. 93 of
We find that the stand of the respondent regarding the petitioner numbers 3, 7, and 8 being overaged. Is it correct? Petitioners number 3, 7, and 8.
3 average.
File has not been sent.
3 average.
3, 7, and 8.
3, 7, and 8. Yes.
Is unsustainable. They are required to process the petitioner's claim based on medical test, as has been done in the case of the petitioners number 1, 2, and 5. 1, 2, and 5
Yes. 1, 2.
have failed the PET.
PET. Yes.
PET.
Yes. 1, 2,
1, 2,
and 5.
and 5.
Yes. Yes.
The remaining 2 have been
Remaining 2
have been given the opportunity.
Oh. Remaining 2 are
4
unqualified. They have said they are the non-metric. That
No, here there are only 2 categories. One is PET.
yes,
and
no, 2 category your lordship has already been said. One category is non-metric. They have said that is that is also average and non-metric 3.
3 is overage.
Average.
For overage, we have directed
Yes.
like other cases, and
Yes.
1, 2, and 5 medical examination.
Yes. Yes.
Okay, I have been directed.
Yes, ma'am.
Therefore, the respondents are directed to conduct a medical test of the petitioners within 4 weeks from date
Madam.
and process their candidature without raising any objection regarding PET and or overage.
Railway Council, it is.
Hey, that judgment your lordship cover.
Where is the Railway Council?
I know that your lordship several times give notice not come.
They have not appeared.
The last occasion they have appeared.
Yes, that we have recorded.
Yes,
Last
yes.
time they had-
My lord, in this matter, my lord, I appeared, my lord, more than thrice. Now, my lord, we have filed one affidavit.
We have passed the order. It has been listed for orders. We have passed the order.
All right. I am grateful to my lord.
Your appearance we are recording. You are not here. Therefore, we were looking for you.
I'm extremely grateful to my lord. Extremely grateful.
That will clear. Ian Rai's appearance should be recorded to get him to.
Number 119.
My Lordship, I appear for the respondents in this matter.
Your Lordship, I am there for the petitioner, my lord. My lord, due to some medical reasons, my lord, I could not go to the courthouse today, my lord. If my lord may kindly be pleased to take it up tomorrow, my lord, at 2 p.m., my lord, I shall address your lordship.
Tomorrow 2 p.m. would not be possible.
My lord, then your lordship was pleased to fix the other matters, my lord. Item number 114, 15, my lord. I could not approach your lordship due to my reason, my lord. On 4th of August, my lord. If my lord may kindly fix, please to keep it this matter also done on that day.
As played, 4th August.
Grateful. Grateful.
4th August, there is some difficulty, Your Lordship.
You are in difficulty.
Yes, Your Lordship.
What is your difficulty?
Not be in town, Your Lordship.
4th August, you will not. 4th August, the respondent is not available.
Yeah.
Okay, the day after, my lord, or on the subsequent week, my lord, on the previous week, my lord, the July last week, my lord.
No. Now
The
let
learned friend.
after that case. 6th,
After 6th, 7th is
7th, 8th August.
Yes. Yes.
As jointly prayed, list on 8th August.
Exactly.
120 and 121.
Your Lordship, I'm for the appellant.
Yes, Your Lordship.
I'm for the appellant petitioner in this matter. In this matter, I'm led by Mr. Sukanta Chakraborty. He's on his legs on a different court. And I have also met with an accident today, a very minor accident, although my car has been damaged. So I am online today. If my matter can be fixed out tomorrow, I'll be very grateful.
You are for the respondent.
My lord,
I'm for the petition.
Your Lordship, from one order challenged by both of us.
Yes.
The Union of India.
In 126, you are for the Union of India.
No, I'm for the petitioners in,
Yes.
in WPC.
I'm for the Union of India.
In 126, you are appearing for the Union of India.
Yes. They're the petitioner.
120 to 121.
126, they are for the petitioner, Union of India. And I'm the respondent.
You don't even know your rate petition number.
Yes. 126.
It's 126.
Yes.
Then why are you saying no?
No, it is 126.
Yes. And you have the next rate petition is by the applicant.
Yes, sir.
This is by the respondent before the tribunal.
Yes, Lordship. But Lord, kindly look into the order, Your Lordship. Lord, retirement benefit has been deducted huge amount. Two of the applicants after the date of retirement.
So
and
why
one,
are you here? What is your problem?
my lord, the interest component was not given, was not allowed by the learned tribunal. So I came for that. And the Union of India has come before this honorable court for allowing my application with regard to repayment the amount that has been deducted from my benefits.
What payment was made in excess?
Lord,
the excess payment has been made on what under what head?
They alleged, my lord, that what I was entitled to, I had withdrawn more in excess of that.
That we know,
Yes,
but excess means what? Excess by virtue of revision or wrong fixation or some benefit has been granted. What is the issue?
That's for benefit, Your Lordship.
Which benefit?
My lord, kindly, Your Lordship. It says, I tell Your Lordship. I'm getting two petitions, so.
Not ready.
My lord, kindly, my lord, take paragraph 9 of the application, of their application, the first one. Paragraph 9, my lord, it states everything.
So it is a refixation. It arose out of a wrong fixation.
Yes, Lordship.
When the fixation was done, the wrong fixation was done at what point of time? What is the date? And when was it rectified?
My lord, we are being informed on 22nd.
You are also not prepared.
22nd, my lord, 22nd.
Just after 1 week.
The
Sorry.
paragraph 9 is there, Your Lordship.
Is this
Speaks of everything.
everything we ask you, you take 3 minutes to reply.
My lord, paragraph 9 speaks of that.
Let him have his adjournment. List
Lord,
after 3
kindly, Your
weeks
Lordship.
as paid. Sorry.
Grateful, Lord.
You're trying to go into it. You are not. Call the
But paragraph 9 speaks of that, Your Lordship.
Yes. Call the next.
My lord, Your Lordship will be taken up.
As paid list after 3 weeks.
এই আস্তে আস্তে
Now 122.
when it was granted when what is the grade in which he is. Applying the principles contained. Only shouting that.
My lord, take it up in the next week, Your Lordship. Kindly, Your Lordship.
3 weeks. Welcome.
My lord, I am for the petitioner in this matter. My lord.
Yes.
My lord, I pray for 2 weeks accommodation, my lord.
3 weeks, not 2 weeks. As played
Get
list
one.
after 3 weeks.
Get one.
Mentioning it a little hesitantly, your lordship remembers that Calcutta Club matter on suspension that your lordships had heard. It was reserved on the 2nd of April, your lordship. I just thought that I'll just mention before your lordships.
Yes. My lord, may I have your lordship's kind leave to
Certainly.
mention a matter? Your lordship had heard the matter last on 17th of June, and the interim order was extended till tomorrow. And the matter was supposed to be listed on 2nd. Somehow the matter had not appeared. Your lordship, if the matter can be taken up tomorrow as to be mentioned.
Tomorrow to be mentioned.
Grateful, your lordship.
Audience side, listed matter.
My lord,
Awarding appeals from order
I had almost finished.
My lord, I pay for the appellants.
Few minutes, one or two things I wanted to point out.
We thought you had already finished.
I finished one or 2 points. My lord will kindly permit me to play. Everybody has placed my order. Only the operative portion may I, for my satisfaction, place my order. That's all. It
Yes.
will not take more than 15 minutes.
Yes.
The first thing which I wanted to, I missed out on the last occasion was that Mr. Mukherjee had relied upon 2 documents. One I had dealt with, saying that the Reserve Bank has not followed its government's policy, relying on the industrial policy document. One document which is at volume 18, page 580. Kindly have a look, my lord. This is the industrial policy handbook for NRI investment, deals with the 1991 industrial policy.
Which
Both
page?
Page 580.
508.
580. 580.
Volume?
Volume 18. Volume 18, that's paper book, volume 18.
Yes.
On the right hand column, in under against Roman 3, investment in priority industries under 100% clean. This is 1991 industrial policy. NRI to OCB are permitted to invest with full repatriation benefits. Kindly mark the words repatriation benefits up to 100% in issue of equity shares and convertible debentures of a private public limited company engaged in purported to engage or high priority industries in Annexure 3, etc. Then contributions received from NRI OCB towards equity shares, convertible debentures covered the foreign exchange requirement for import of capital goods. So money is to come, investment envisaged, then foreign exchange, with that foreign exchange invested in India will cover the cost of capital goods on repatriation benefits. In such a case, the capital goods imported must be new. This has got nothing to do with the present case, because in the present case, directly second-hand equipments were purchased and brought to India. So this policy does not deal with that situation. That is dealt with by the export-import policy, which Reserve Bank has relied upon in giving the permission. So this has got really no relevance. Originally, the company had contemplated to pursue under this scheme, invest 800 crores, and with that investment bring in buy machinery. First bring the money in the country, then out of that capital goods will be purchased, which must be new. That has got nothing to do here. Eventually that was not pursued. What was pursued was to buy directly second-hand capital goods, for which permission was sought for. So the 2 documents at 575 and 580 dealing with the industrial policy of 1991 has got nothing to do with the present permission given by the Reserve Bank to the company to import second-hand capital goods. This is how I deal with that submission. Now, may I just conclude by placing my operative portion of my order. My order is at, my lord, my compilation. I have handed over my one compilation of Reserve Bank.
Yes.
My order is starts from page. I'll only read the operative portion. It starts from page 23 of my Reserve Bank's compilation. I'll start, my lord, from page 36, the operative portion. Page 36, last paragraph, the order. It starts from order. Has your lordship got that?
Yes.
Order. I have given a patient hearing to both the parties. The petitioner, Sri Sajal Datta, during his submission, which covered the whole of 22nd April and first half of April 23-24, had made long submissions. At the conclusion of the first day's submission, he asked for all the documents regarding correspondence between RBI and Mr. Dr. K.K. Datta and Associates, the 95 till date, to enable him to proceed further in his submission. When he was asked repeatedly to specify the approximate time required by him to complete his submission, refused to do the same. Though he had agreed to make a written submission during the hearing, he refused to do the same on the ground that sufficient time and the required documents were not furnished to him, and as such he took the stand that the proceeding was vitiated, and refused to make any other oral submission when he was given in writing on April 27, 2024, a time of 3 hours from 11 a.m. to 2 p.m. on 30th April 2004. He also refused to make any written submission, though he had omitted the same at the conclusion of hearing on 23/4/2004 by asking for unspecified time for oral submissions and insistence on all documents in 1995 till date it appeared that he was only adopting delaying tactics deliberately. I am of the opinion, then the actual order starts. I am of the opinion that the Reserve Bank has a rather limited role under the provisions of FERA 1973 in the dispute between the parties, and there are three issues to be addressed. I'll be addressing them serially as follows. Then first issue, the section is quoted, 19(1)(d). Then from the above, it is clear that any person, which includes a company, can issue shares to NRIs only with the prior permission of RBI for issuance of such shares. The issuance of shares can be on repatriation or non-repatriation basis. Both are different. RBI permitted issuance of shares on repatriation basis when foreign remittance was received through normal banking channel. That is the industrial policy of 1991. Normal banking channel, and when there was capitalization of new equipment. In such case, the investment will come in and the capital equipments would have to be new, because it is on repatriation basis. If the equipment, then I proceed with the order, equipment supplied were second hand, then the capitalization of the same was allowed on non-repatriation basis, which the RBI has done, is allowed import of second hand on non-repatriation basis. Admittedly, in this case, the equipments supplied by Dr. K.K. Datta were second hand, and there is no dispute on this point. SIA approval was obtained on 16th August 1993, in which non-resident equity participation allowed 88.88%. SIA later also stated that the project envisages import of capital goods worth 420 lakhs to be financed out of NRI investments. The import of equipment was governed by the then import exim policy, in terms of which there was no restriction on import of second-hand capital goods. Now, this exim policy, pausing here for a moment, Reserve Bank, which is relied upon, I have annexed to my compilation that exim policy. That is at page 43 of my compilation, the exim policy. And the relevant portion is at page 49. My lord will kindly mark. The export-import policy which is relied on by Reserve Bank of India is, I have annexed it, it has page 43. At page 49.
Just a minute.
I'm sorry.
Page 49.
Yeah, 43 at 49. Your Lordship has seen that. I am not repeating it. Mr. Mukherjee and Mr. Mitra, both they have placed it. The only thing which I wanted to point out, kindly come, I'll give your Lordship the trouble, kindly come to 49 once, just for a second. Clause 25, my lord. Import second-hand capital goods without license. All second-hand capital goods having a minimum residual life of 5 years may be imported of the actual users without license, subject to actual user conditions. The actual user shall furnish to the customs at the time of clearance of goods a self-declaration to the effect that the second-hand capital goods being imported having a minimum residual life of 5 years in the prescribed form as given in Appendix 11 of the Handbook of Procedures. If the CIF value of second-hand capital goods being imported is rupees 1 crore and above, the importer shall also furnish to the customs at the time of clearance of goods a certificate from an inspection and certification agency as specified by the Director General of Foreign Trade in this regard behalf, to the effect that the purchase price is reasonable. These two obligations were towards customs, and since customs has cleared the goods, the Reserve Bank did not proceed further on these issues. It was to usurp the jurisdiction of customs authorities.
Yes.
Now, I was placing my order at page 36 to continue with RBI's order from page 38, Exim policy, in terms of which there was no restriction on import of second-hand capital goods. Thereafter, on 4th November 93, in principle, approval was granted by RBI for issuance of share on repatriation basis. This is the first when they had applied for SIA approval for bringing in money under the industrial policy. This permission on repatriation basis was given, but that was not pursued. So he mentioned that initially Reserve Bank is giving that during financial year 94, 95 and 95, 96, Dr. K.K. Datta supplied, imported, this is the thing, second-hand medical equipment and applied for shares against the second-hand equipment. The import of such medical equipment against which shares were to be issued pending RBI permission for the same was reflected in the annual report and balance sheet of the company for the year ending 31st March 1995 and 31st March 1996. This fact was also known to Sri Sajal Datta as he had signed the above balance sheet as director of the company. The above balance sheet was also showed income of rupees 100 lakhs from out of operation of the hospital, obviously with the use of equipment supplied by Dr. Datta and commissioned by the hospital. The permission granted by RBI vide its letter dated 22nd March 1997 was on the basis of RGI Ruby General Hospital application dated 17th March 1997, signed by Dr. K.K. Datta as the chairman of the company, enclosing thereto all the requisite documents. The same was scrutinized by Exchange Control Department of RBI Kolkata. At that point of time, the regional office of RBI was delegated with the powers of approval for permission for issuance of shares on non-repatriation basis. Permission was granted by ECD RBI Kolkata after scrutinizing all the required documents submitted by RGL and after finding the same to be in order, And at that point of time, RBI Kolkata did not have the information that Dr. Kamal Kumar Dotto had ceased to be the chairman of the company, and there was the board resolution of the company not to apply for shares against the second-hand equipment. Hence, the act of RBI Kolkata was based on the documents paper signed and submitted by Dr. Dotto representing himself as the chairman of the company. Therefore, the aforesaid permission was granted in good faith and without negligence. Dr. Dotto took delivery of the permission letter addressed to RGHL in original personally, which was given to him, and he represented himself as the chairman of the company, and as such the letter was not posted to the company at his registered office. The permission was objected to by the Jubi General Hospital represented by C. Sajal Dotto, the managing director of the company, vide its letter dated 27 May 1997, mainly on two grounds mentioned earlier. RBI Kolkata withdrew the approval letter dated 22/3/1997 on the basis of this complaint. However, RBI Kolkata, in good faith, believing in the representation of Sri Sajal Dotto, withdrew the approval letter issued by RGH and handed over to Dr. Dotto on 22nd March 1997 by issuing another letter dated 26/97, a copy of which was endorsed to Dr. Dotto. Dr. Dotto represent against the same. The representation was examined by the bank, and a decision was taken to maintain status quo. And in view of the fact that Dr. K.K. Dotto, NRI Invest, had already made payment to the suppliers of second-hand machineries abroad, the aforesaid decision of bank was communicated vide March 6, 1999 to RGHL. Now, this paragraph is very important. My lord, the next para is very important. Incidentally, RBI then...
Yes, the last sentence is important for you, perhaps. We have seen it.
Yes, that
Therefore,
they relied on the company law board order. That has been subject to correction. I have got that judgment that went up to Supreme Court. The Supreme Court has affirmed that company law board order. I have got a copy of the Supreme Court judgment. Mr. Mukherjee, I think, handed over. Mr. Mitra, my lord, got copy. My lord, the judgment is in Mr. Mitra's compilation. I'll just point out the paragraphs.
Yes, we have been taken through that judgment.
Yes, paragraph 1, it mentions the CLB order, and it approves that CLB order.
Correct. That is...
So the Kamal Dotto was justified in making that application, and that resolution...
So you are saying he was justified in making application, and you are also saying that because ultimately they aborted the initial application and they switched over to non-repatriation basis, therefore second-hand machinery, there is no fault.
That is under that we are covered by the export-import policy. That is my simple submission. But next page is the second issue. Second issue is whether the approval shall be on non-repatriation basis alone. Next page, 40.
Next page.
Next page is that second issue, whether the approval shall be on non-repatriable basis. Second issue. Page 40 of my compilation. 40. As discussed above, the equipment supplied by Mr. K.K. Dotto were second-hand. The company had received and utilized the same for which Dr. Dotto had made payment abroad. Since as per the existing policy of RBI, capitalization of second-hand equipment could be permitted on non-repatriation basis only, I am of the view that permission shall be granted for issuance shares on non-repatriable basis. Here, my lord, RBI has relied upon that DO which was placed. I have annexed to the DO issued by Government of India. That is at page 51 and 52 of my compilation. Yes. Page 51 and 52 is the DO dated 3/1/94. Page 51, kindly come to my lord, last paragraph. Page 51 is the DO, last paragraph. Repatriability of such investment of NRIs against direct payment of imported machinery which are second-hand equipment. This, the policy is in page 52. C, page 52, C, A, B, C. In all such cases where the amounts are paid directly by NRIs against import of second-hand capital goods, the investment is permissible only on non-repatriable basis. This is from the foreign exchange point of view for conservation of protection of remittance outside India. Yes. And my lord, the third issue is what? Third issue, whether there shall be any monetary limit or limit to the number of shares. This is the permission shall be granted for the issue of 30,55,329 equity shares of 10 each against import of second-hand medical equipment to Dr. K.K. Dotto, NRI investor on non-repatriation basis, for which he had made the payment abroad and in support of which he has submitted documentary evidence at the time of making application, which was scrutinized and found to be in order. So this is the order of my lord. I wanted to place my order. This is the order of RBI. Yes. This I conclude my submissions. I prepared a short note, my lord, will permit me hand up. The case laws I had relied upon two earlier that they are included. I had submitted on the first day. My lord, I am grateful, my lord. Yes. Yes. You can, no problem. But we will not be able to continue tomorrow. Already have some matters assigned for tomorrow in the second half. So you can conclude at 3, then we'll fix on another date. That will perhaps be the last date.
right? এটা দেখাচ্ছি দেখাচ্ছি কোথায় থেকে দেখিয়েছি আমাদের না না এইমাত্র এটা দেখালো না ও ওটা ভলিউম 18 থেকে দেখালো 18 থেকে দেখেছি হ্যাঁ Now, my lord, my learned friend, my lord, addressed your lordship and my lord, they also did, my lord, on exit policy. My lord, kindly take up, my lord, the volume 18. Now, ওটাতে নেই। Now, kindly come to page 575, my lord, the industrial policy, lordship should find relevant features of statement on industrial policy dated 24 July 1991. Sorry, page 575.
Yes.
Page 575, my lord, after the heading, note for guidance. Then, my lord, the next. Relevant features of statement of industrial policy dated 24 July 1991.
Yes.
Then, my lord, Reliance was placed, my lord, kindly come to page 585. Kindly come to clause 24. Under my lord, the heading inputs, chapter 5. Page 585.
Yes, import of second-hand capital goods.
Now, before that, my lord, kindly come to 24.
Yes.
Notwithstanding anything contained in paragraphs 22 and 23, second-hand capital equipment and any other second-hand goods shall not be imported unless permitted by this policy or in accordance with a license issued in this behalf. This was 1991. Now, next, kindly come to 25. All second-hand capital goods having a minimum residual life of 5 years may be imported by the actual users without a license, subject to actual user condition. The actual user shall furnish to the customs at the time of clearance of goods a self-declaration to the effect that the second-hand capital goods being imported having a minimum residual life of 5 years in the prescribed form as given in Appendix 11 of the Handbook of Procedures. If the CIA value of second-hand capital goods being imported is rupees 1 crore and above, the importer shall also furnish to the customs at the time of clearance of goods a certificate from an internationally reputed inspection and certification agency to the effect that the purchase price is reasonable. Now, my lord, I proceed on the basis that this was done, otherwise the customs would not have allowed the importation. Now, interestingly, my lord, kindly come to page 595. Kindly come to page 595. Lordship should find, my lord, it's a DO, my lord, issued by the Government of India, Ministry of Finance, Department of such Economic Affairs. Date, kindly take note, 3rd January 1994. Policy was modified in 1994. Now, kindly come to, my lord, the letter. Dear Sir So-and-so, please refer to the communications from the Reserve Bank of India referring to the following proposals from the companies detailed below for GOI concurrence advice. Now, kindly come to the first one. RBI's letter numbered such and such dated 2nd December 1992 proposal. Application from Mrs. Prono Brothers Private Limited for issue of equity shares to NRIs against direct import by NRIs of second-hand capital goods under 100% scheme on repatriation basis.
Then kindly come to bottom, my lord, clause 2 or paragraph 2. The specific issue raised in these cases are: number 1, capitalization of direct payment by NRIs against the import of items through issue of shares. 2, repatriability of such investment by NRIs in cases of direct payment against imported capital goods which are new. Kindly take note, repatriability of such investment by NRIs in case of direct payment against imported capital goods which are new. And then 3, repatriability of such investment by NRIs against direct payment of imported machinery which are second-hand equipment. Now kindly turn the page. Sorry, 597, yes. Kindly come to the top, my lord. On these issues, RBI may take action as follows. Kindly omit, my lord, A and B. Kindly come to C. In all such cases, where the amounts are paid directly by NRIs against import of second-hand capital goods, the investment is permissible only on non-repatriable basis. So this was the policy. And this policy was oh, yes. Yes, and the next. I'm sorry, thank you. Reserve Bank of India may consider this and similar other cases on the basis of government's decision indicated above. Thank you. And that is exactly what had happened.
Yes.
Is it legible, my lord?
Yes, it is.
Yes. Typed copy is there, my lord, page 590. আমার বিশ্বাস হয় না type. Now, kindly, this exim policy but this exim policy is governed by, my lord, the Foreign Trade Development and Regulation Act. Now, kindly look into the act once. But kindly come to the definition part, section 2D. In this act, unless the context otherwise requires D, Director General means the Director General of Foreign Trade appointed under section 6. Now, my lord, kindly come to section 6, my lord, or 5 and 6, my lord. Kindly come to section 5 first, my lord. Next page. The central government may, from time to time, formulate and announce by notification in the official gazette the export and import policy, and may also in like manner amend the policy, which was done in 1994. Then kindly come to 6. The central government may appoint any person to be the Director General of Foreign Trade for the purpose of this act. Now, my lord, kindly turn the page. Kindly come to section 11. No export or import shall be made by any person except in accordance with the provisions of this act, the rules and orders made thereunder, and the export and import policy for the time being in force. Then, my lord, kindly come to, lordships will be pleased to come to section 13. 13? 11 টা দেখো আচ্ছা তো দেখো or my lord, kindly come to 11 subsection 2 once.
B. Subsection
2. Section 11 subsection 2.
Yes.
Where any person makes or abets or attempts to make any export or import in contravention of any provision of this act or any rules or orders made thereunder or the export and import policy, he shall be liable to a penalty not exceeding 1,000 rupees or 5 times the value of the goods in respect of which any contravention is made or attempted to be made, whichever is more. So, provision of penalty.
Yes.
Then kindly come to 3, subsection 3, where any person on a notice to him by the adjudicating authority admits any contravention, the adjudicating authority may in such class or classes of cases and in such manner as may be prescribed, determine by way of settlement an amount to be paid by that person.
You're reading 11.3. Where any person signs or uses or causes to be made.
There are amendments after, my lord.
So this is the unamended one.
Sorry, my lord. May I come with the unamended one, my lord, on the next day? I was reading from the original one.
This is a subsequent amendment.
Yes. This is subsequent amendment. 2010 and 2008.
No, because we couldn't follow what you were reading, that's why.
I'm sorry, my lord, you ought to have been more careful.
Yes.
May I stop in that event, my lord, today?
Yes. So we'll start with this Foreign Trade Development and Regulation Act. Yes.
My lord, could it be kept any day other than Monday next week, my lord? We'll have to take instructions.
Discuss amongst yourself.
We might fight, my lord, for the other things, but definitely we shall agree about this 21st July.
Oh.
I once took chance of getting out of my house and trying to come to court. I was stuck in the road for about 2.5 hours. After that, I have decided not to venture again.
On this date, I was here last year. I don't remember what happened, whether we had come to court.
Completely paralyzed.
Was it a weekend last year? I don't know. I don't know.
My lord, one thing, my lord, I must insist upon may the counsel for the RBI, my lord, make over a copy of the note, my lord, that was submitted.
Yes, you should give a copy to everyone. He'll give you.
Very.
Just tell us a date, agreed date.
Thank you, sir.
You should return this. Is it better that we give this back to you? Since we are not relying on this, ultimately it will only cause confusion if we have to win the records. When should we? Do we have any matters fixed in the second? What? Can it be on?
I'll just confirm with Mr. Mukherjee, my lord. In case, my lord, there's some inconvenience on the part of Mr. Mukherjee on 30th, my lord, we'll mention and we'll.
Why don't you find out right now?
But then kindly gives me, my lord.
Yes, yes, please do.
Keep your pledge. I'm just 5 minutes.
Both dates are clear for us.
My lord, kindly gives me a minute.
हाँ कल तो
Oh, 30th, my lord. 30th. 30th is fine. 30th
you are
is fine.
sure
30th is fine.
this for further
30th.
consideration on 30/7/2025.
Lord, usual time, my lord.
Yes, 2 p.m. it will be.
Keep your pledge.
I hope it's.
My lord, I'm for the appellant. I'm led by Mr. Vishwarup Biswas. I'm led by Mr. Vishwarup Biswas, but he's not able to attend the matter today. My lord, I'm praying for not this week.
Last day also it was adjourned.
No, my lord, wasn't at home.
Yes. What do you mean? No, we are looking at the order. You are saying no.
My lord, was most probably, my lord, he wanted time to show some judgments. That's why.
What is wrong with the tribunal's order? Where have you said in your application about your level of disability? What is the percentage? Let us see.
Number 3, my lord, in the
4.3.
No, 40%. 40%.
No, but you have claimed this 40% disability on the basis of certificate issued in the district. Whereas in the recruitment process, they have identified few centers where it has to be done within Calcutta. That is a central kind of a thing. So at that place, you have been found, one of you has been found 0% and one has been found below 40. There are two applicants.
My lord, there are certain judgments which state that once a medical test has been done, it cannot be again be a requirement for at the time of giving the employment.
That's correct. So once it has been done in the central centers,
yes.
then where's the question of reopening? And that's precisely what we are saying.
My
On
lord,
what ground you say that this is wrong?
my lord, my senior, he was supposed to show you some judgments.
Show it. Where is it? Show the judgments. Can't be adjourned
I
every
do
day
not
just like this casually.
In the my lord, the orders, my lord, that has been passed below, it has been specifically mentioned that he is not come within the criteria that has been mentioned.
Where is his assessment?
Well, assessment is, if lordship takes, my lord, page 179 once.
How many applicants were there?
There are so many applicants, but here, my lord, only one has come. Others have not come because they have accepted that.
They have accepted the tribunal's orders. So only one is before us.
One is here, my lord, it has been mentioned to the OSD EO, that has been by Director of Health Services, medically unfit candidates of clerkship with reference to the subject mentioned above. The letter of Srimati Devika Karmakar, the petitioner herein, my lord, dated so and so, has been forwarded to this end. Srimati Karmakar asked that I was unfit as per PWD Act 2016 as my disability is less than 40%, but sir, according to PSC Clerkship Notification 2019, our medical is supposed to be done as per PWD 1999. The answer is, in accordance with the memo bearing dated so and memo bearing dated so of the H and FW Department, Disability Board of Medical College and Hospital follows Disability Act 2016, which is more current than the PWD Act 1999. This office has no authority. And in the notification also, my lord, it has been mentioned in my lord, page 177, my lord, in page 1 on that notification, my lord, in the middle portion, each of the aforesaid categories of the handicapped person has been classified into the following 4 groups: mild less than 40%, moderate 40% and above, severe 75, and profound or total is 100%. So my lord, he has not come within this zone. And my lord,
So unless it is moderate, they may not be considered for any benefit. That is the advertisement.
And in page 176 also, the case of Srimati so and so, this has been discussed, my lord, that it was mentioned that a relevant advertisement, the benefit of reservation of the vacancies are admissible to the PWD candidates with disability of 40% and above, which is envisaged in the notification dated so and so of women and so and so. It was mentioned in the said advertisement, candidates who will be selected for appointed will be required to appear before a medical board for certificates of their fitness of government services in the prescribed for this purpose. Moreover, as per advertisement, it was clearly mentioned that if at any stage, even after issue of the letter of appointment, a candidate is found ineligible in terms of the advertisement, his or her candidature will be cancelled without any further reference to him or her. So that has also been mentioned, Miller.
What was the date of advertisement?
The advertisement.
Where is the advertisement? Let us see just.
Advertisement, Miller, at page 60, Lordship. This has been by public service.
Every page has 4 page numbers.
The problem, Miller.
5 page numbers.
And apology to
2 minutes I'm taking.
You allow her to wait. So the facts are not in dispute. The advertisement required a central medical board to examine. That is not in dispute. And it is also not in dispute that they have certificates issued by the district medical officers who certifies it to be more than 40%.
Subsequently, it has been found that he is not more than.
But in the recruitment process, they have not been found to be 40%. And what is her assessment? Less 0 or how much percent?
No, 30.
30.
And in the advertisement, there was a mention clear. 99 rules will be govern the field. Advertisement itself is a bad. I cannot challenge it, but because I have participated, because selection process started for that post of clerkship in the year 2019.
Oh,
when
after coming into
yes, and at that point of time, 2016 rules were in vogue. They could have proceeded to that. They proceeded in the terms of 99 rules, knowing fully well. Now I,
So what is the difference? How you are prejudiced? That
prejudice because they cannot take them in the opposition. They have only taken the plea that medical test further, although there is no provision for further, because the one government authority, if issues a certificate for the purpose of making disability, but after 4 years, there may be curable or incurable. I do not go into that aspect, because everyone wants, by getting a modern treatment, can be
there are various conditions. Which can
so
improve.
they cannot defute this by making further. Right to life first, job is second.
We are asking you what is the prejudice, whether it is considered under the 99 Act or the
2016 rules 20 itself says if any document issued in terms of the earlier rules that is valid for 10 years, there is no further adjudication to that effect. Already protected my right. Without considering that, but I do not know the medical.
Therefore, you want to rely on the certificate issued by
99, that is 65%.
Therefore, we said, where is the advertisement? Let us see what the advertisement.
Yes, kindly sees. Advertisement, thereafter I am taking one after another, everything.
But
advertisement at page.
Some pages have 5 page numbers. We are unable.
I am giving the advertisement page 60, 61. It starts from 60, 61 is PW column number 2, physically handicapped with 40% disability. So in 61 column number 2 top. In respect of other also 40%. It has been mentioned. Now kindly come to page 62. Got is page 62. For person with disabilities, middle portion. Both.
What is the nature of disability that you are claiming?
Hearing impediment. I have submitted all these documents, selected, recommended only on the date of appointment, but they have made another medical test, and that has been in the year 2023, after 4 years. Kindly see, West Bengal Person and Disabilities Protection Rules, full participation rules 1999. My lord got it. In the advertisement, it is mentioned itself. So I shall go by that.
Page
62, middle portion. They have not said.
What does it say? Read.
The Bhai West Bengal, how medical board constituted at the Medical College Hospital, Kolkata, comma.
Yes.
Then district hospital, my case. It is issued by the district medical hospital, Midnapur. Government document. Whether subsequent it can be disbelieved by another authority. Sitting in appeal over the assessment already given.
Disbelieving, another test was performed.
Whether this can be after 4 years.
Another
it can
test
be.
Has been performed. And my lord, I have shown to his
now.
lordship.
Please, Dada, please. Now, my lord, if your lordship kindly sees my next page. What is there?
So, which certificate you are relying upon?
Yes,
Let us
I have annexed this.
My lord, kindly take my medical certificate at page 28. It is issued on 8 January 2019, immediately preceding the advertisement. Page 28. কেন মিলবে না? P1 প্রথম অ্যানেক্সারটাই দেখো, অরিজিনাল অ্যাপ্লিকেশন দিয়ে বলছি আমি। হ্যাঁ এইটাই তো, ওটা না না, তুমি 28 পাতায় দেখো, মানে 59% হিয়ারিং ইম্পেডিমেন্ট হ্যান্ডিক্যাপনেস issued by certificate of disabilities, office of the medical superintendent, vice principal, Midnapur Medical College and Hospital, Paschim Midnapur, top of the document. Percentage of division 59%, and it is valid. Validity kindly sees. I shall take the 2016 rules itself. 8/1/2029. And kindly come to their opposition, how they have dealt with the paragraphs. Reply. In fact, it is reply before the tribunal. And subsequent, my lord, page 32 is the subsequent percentage of disabilities issued by the another government hospital, medical certificate appointments of candidate in respect of my client in the year 2023. Shows 30%. Page 32.
Page
32.
That is the
just before issuing of appointment letter, after recommendation. Page 32. In the year 2023, 20th January 2023. Whether they can
It's not that it was not being found. Sorry. Yes, it's 15.
So the certificate does not indicate the method of assessment, how it has been done.
And we are not the person to expert to that. No, nothing has been mentioned.
No, you are not.
Only
That we
tested,
understand.
and my lord, it is repeated.
We are expert of experts, so we can look at everything.
We are trying to learn. How the possibilities, how the distinction between the 99 rules and 2016 rules, we are not conversant, my lord. I am candidly submitting.
Okay. Yes. Was any opposition filed in the
Yes, my lord, I am taking to kindly seize the enter.
His lordship, since page 32, my lord, you will find, lordship will find, my lord, that general development fair. At the top, my lord, lordship will find that where disability has been comes reduced to 30%. Now, my lord, here it has been mentioned, my lord, general development is good, stroke fair, stroke average, stroke poor. So general development, if his lordship takes that, my lord, so after 4 years, he may be, my lord, improved. And
General
in the
development-
advertisement, and in the advertisement, my lord, it has been mentioned.
General development does not mean that. One thing is, we want to bring it to your notice. Page 28. The name of one person who is mentioned in the bottom 3 boxes. In the central box, he is an audiologist, a person who examines the hearing capacity. In 32, there is an orthopedic, Department of Orthopedic, Associate Professor Orthopedic, how he will assess a hearing impairment.
My lord, 32 is a board.
Yes,
Person, doctor gulo.
we are talking about the doctor who comprise the board.
Yes.
He is not an audiologist. How he has certified the. Whereas in page 28, the certification is by an audiologist.
Correct. It's my fault. I could have.
Now, my lord, in middle portion, my lord,
Yes.
lordship will find Bijon Kumar Odhikari,
Yes.
Professor, Assistant Professor, Department of ENT, Medical College and Hospital, Kolkata.
Where are you reading? 32.
In this portion, but just above that page 32, my lord, lordship will find, my lord, 3 names are there. Just top. Just top.
Department of ENT, that's all right. That's why we said, how do you.
This is the board. The medical board has been formed for this purpose. So medical board has examined. These board consists of 4 doctors. This ENT and other.
দাদা ভুল বলছো তুমি
No, no, no.
এই দেখো শোনো শোনো 3 জন নিয়েছে 3 জন মেডিকেল এক্সপার্ট ছিল উপরে ওটা অথেন্টিকেট করেছে উনি হি ওয়াজ নট অথেন্টিকেট
I have to understand also what you are saying. I also have to understand what you are saying.
I'm telling there are 3 medical experts
Yes.
as you lordship already held and the authority of ENT only authenticated their views not by the ENT specialist.
The board is of these 3 persons. Appears.
Yes.
So
And
these
only
3
authenticated
persons.
person is Vision.
This has been affirmed by the ENT, Department of ENT, verified. But kindly see, verified.
Verified, yes. But the test is not by this ENT person.
That we who has, but test has been done, and nowadays lordship seen, my lord, all the test reports. Considering those reports, my lord, they have submitted this. Everything is on the basis of a report.
There are 2 options.
এটা হয় না চঞ্চল ধর এটা একদম ভালো না যে ENT
What is the need for doing this? When the advertisement says district is also permissible, why did you do it?
Maybe, my lord, maybe some suspicion situation arises. Maybe
এটা-
nobody knows. In some
Suspicious cannot take the
matters,
place
I have find also, my lord, even after, my lord, he has shown that he has disability. Certificate has also been shown. Thereafter, court finds a medical team was formed. Court send him. for
Yes, yes.
medical test.
That is, see, that is
And
not,
the person doesn't appear in that medical.
that is not uncommon. But here we are seeing that in both the tests, she has been found to be suffering with impairment. Only the degree is varying. It is not that the subsequent test has said that she has no impairment.
No, test
Only
has
the
been
degree
done.
has been
reduced.
Maybe it may be, my lord, it may be after 4 years, influx of time.
No, because the first report says it cannot improve. You see the first report. Clause 2, just below. This condition is progressive, non-progressive, likely to improve, not likely to improve is ticked. So there is no question of a improvement.
It's very difficult to answer your lordship these things, my lord. And my lord, so far this page 28 is concerned, my lord, it has been signed by the chairperson, medical superintendent cum principal and chairman, handicap board, Midnapur Hospital. But kindly see at the bottom, my lord,
Yes, he is a medical superintendent. He is cum principal and chairman. He is basically a medical superintendent. He is a doctor, and a test has been conducted by audiologist who is a specialist for this. Whereas in the subsequent test, one orthopedic doctor has taken the test and it is verified by ENT, and still they have not said that there is no impairment. How they have assessed?
Then lordship, in that event, lordship from the medical board.
আর কেন? No, it cannot be. এটা হয় নাকি? After 7 years, law does not permit, sir.
If at be the so, let him.
No, kindly see the rules itself. I am protected by rule 20 of the 16 rules itself. Validity period for the period is sacrosanct in respect of the earlier. Sorry, when I tender apology, I have got one book itself. I am marked also. If any certificate of disabilities issued in terms of the earlier act and rules, it is valid for the period as mentioned in that rule itself. And I have got the rule itself 1999. So I am protected by this.
The submissions is concerned,
That is not the issue. That is not what they are saying.
So I believe that in the opposition they also did not take this type of plea also.
Why this test was required? That is what we are asking. Why it was required? What is your case?
Yes.
When she has produced a certificate from an authority as per advertisement, why this test was conducted?
Obliged to your lordship. Much obliged.
If this was not by an authority not authorized under the advertisement, we could have understood. But we have seen the advertisement. What was the occasion? You must have said something. We can understand if one of these three persons who have certified has been proceeded against, that he has been issuing false certificates or something like that. What is the reason?
My lord, if his lordship takes, my lord, the opposition. Let us come by this opposition.
156 onwards. 156 onwards, paragraph 6 at page 159 onwards. My lord, kindly read the entirety. Nothing disclosed. Only it is the new act. More. My lord.
Let him.
Yes. 156, column number 6 onwards. Kindly read. Enter.
My lord, skip first two paragraphs, the basic paragraph. Paragraph 6, my lord, the answering respondent begs to place the following preliminary submissions on the core issue. It is to be mentioned here that the Personal and Administrative Reforms Department only dealt with the candidature of the applicant number 2 herein and the applicant number 10 herein for the present original application. The letter of memo dated so-and-so 23 was sent to the Deputy Director Health Services, Directorate Health Services under Department of Health and Family Welfare, Government of West Bengal, requesting for medical examination of applicant number 10 herein along with 78 candidates. So this R1, my lord, is letter dated 13/10/2023.
The undersigned is directed. And to be so good as to arrange for their medical of reassessment. There is no issue of just as it appears from this letter. This is a general medical examination before any appointment.
Before any appointment. Now, my lord,
There is no question of going into the disability. This, he says, just see, this therefore requested to kindly acknowledge receipt of the list of candidates
My lord.
and to be so good as to arrange their medical examination. This is a medical examination is conducted for everyone.
Everyone. Now, my lord, examination has been held, my lord. These two persons has found, my lord, that they have not come within the zone. Now, my lord, in the advertisement.
That was not the purport of this letter.
But so far the advertisement is concerned, my lord, it has been specifically mentioned, my lord, at any point of time, if any appointment letter also been issued, my lord, if it is subsequently found that, my lord, he is not within the zone of consideration, my lord, then it may be in advertisement, my lord, it has also been mentioned.
Disability level.
This was not done for assessing her disability.
The general test.
This is a general test. Just see the tenor of page 32 again. At the top, it says medical certificate in case of appointment of candidate. This is not assessment of her disability. During the process, they find that she is visually hearing impaired. So they mention that she is unfit because she is having a hearing impairment. Just see what it says. At the top, it says medical certificate in case of appointment of candidate under Government of West Bengal. At the top, page 32. Just below Government of West Bengal.
Candidate under Government of West.
So this is for the appointment. This is not for assessing her disability. Now see where they have found it at the bottom, clause 2. Unfit on account of 30% hearing impairment. That is a demerit in her candidature that she is not having proper hearing. They have not assessed.
But this has
There is no assessment.
But this has been this medical board has been formed, and this medical board has
No, this is for appointment. This is done in every case, whether claiming disability or not claiming disability. Because everyone who gets appointment has to undergo medical examination.
Yes.
This is the general medical examination. Why?
But in the notification, in the advertisement,
Yes.
His Lordship takes that, then this clause is, my lord, may I just show to His Lordship, kindly comes to, my lord, page 63.
Just a minute.
How are you concerned? They have not been. You know, within house meeting, there's more than 50% difference. Non-African, Given story. But see how many applicants there are. 18 have. 17 have accepted their plea. So let's see everybody. They are making way for other. That is what. By section 2. That says also
In the act that you are relying upon,
16 Act.
yes, is there any provision how the certificate is to be cancelled?
Yes.
Where
it
is
there?
that?
It is there, my lord, in 1990. It is there. Rule 52, I believe so. My lord, it is flagged, I believe so.
My senior has.
We can see what is going on. Yes.
Same point has been
Conspiracy.
decided by the High Court.
Yes.
That medical board has no power to declare disability as has been certified by the district board. Then when a matter
Thereafter,
went up
sir.
Supreme Court,
Ah.
and the division, honorable division bench directed us to give an appointment as a disabled candidate. Then when the state preferred appeal before the SFP, then but Supreme Court again directed to appear before the AIMS. AIMS certified that this is the disability rate.
The judgment, may I have
4 pages, sir.
4 pages judgment.
If subject to correction, all right.
Let us see. Let us see.
Let us
What is
see.
the harm? Let us see.
No, let us see. And if that is so,
Ah.
then entire my lord, appointments.
No,
will
it
go.
appears, see,
If that
prima
is so.
facie, based on the documents, all persons cannot be having a false certificate. So it is just a medical examination by a board.
That's what I'm saying.
And at that stage, how every disability certificate can be made? So if it has to be cancelled and benefit has to be taken away, it has to be in accordance with the act and rules.
Yes.
The certificate was issued prior to the act of 2016.
Correct, but 2016 Act says certificate issued under the elder Act will be valid.
But it has to be tested by the medical board.
Where does the Act say so?
Sir,
Where does it say so? There is no such provision.
no.
Now, my lord, may I just read, my lord? The claim of the respondent was that he was suffering from 40% hearing disability and was thus qualified to raise a claim for appointment against the post of reserved under the provisions of the so and so. Thereafter, in this regard, the respondent relied upon the certificate of disability issued in favor of the medical board, Lalbagh Subdivisional Hospital in 2017, certifying that he had 40% hearing disability. Now, my lord, the authorities, however, doubted the genuineness of the said disability certificate and consequently referred the respondent to Central Medical Board, Kolkata, for re-verification of hearing disability.
But that's not the case here.
Yeah, that is different.
That is not the case here. That's
I apply.
precise.
I apply.
Here,
I just
the only things is, my lord, before giving him appointment, because he has
This is a general test.
general test. Now, my lord,
Everybody has to undergo that
now, my lord,
test.
in the general test, my lord, if
And
it is
such a casual finding.
may I just say in this way, my lord, in the general exam.
So give us that judgment. We'll consider. Give him also a copy. We'll. No,
I
right
know
now we can't. Just
I know because it is distinguishable. That's why I did not place. Otherwise, I could have placed this.
no. Give us copies. Take out printout. Take 2 printouts. Take 2 printouts.
And I have the division bench judgment against which this judgment passed. I have brought this, and I did not place for that reason because my case is totally different.
Orthopedic surgeon general. That's why we looked at why, he asked you why, after all, why this assessment was done. Then we saw
This is
that this is a general, general medical
that
exam.
has been mentioned in our opposition also, my lord. We
Yes.
have mentioned that, my lord.
So there is no assessment by a specialist. It is a general assessment. They say that she is not able to hear properly.
In paragraph 2, my lord, Director Health Services under the Government of West Bengal requesting for medical examination of the applicant number 2 along with 62 candidates. Thereafter,
We have seen that letter. We have seen that letter. See that every employer must be issuing a letter like this. Every employer must be issuing a letter like this before giving the appointment order.
Yes,
That go for a medical examination.
general test. So now in that medical examination, subsequently
There is no assessment of disability.
I am not on that. Now, my lord, if it is found, my lord,
It's not found.
My lord, it has been brought to the notice that he is, instead of 40% or what he has said, 59%, that has been reduced to 30%. Now, my lord, what I was relied on, my lord, that is at page, the advertisement itself. The advertisement said, my lord, if his lordship takes the advertisement once, my lord, in page 63, my lord, page 63, my lord, it has been mentioned, column 3, my lord, if at any stage, not kindly see
কোনটা বুঝছো?
in paragraph 3,
না
page
না
63.
না না তুমি 63 এই জায়গাটা দেখো।
No, I'm 63 এখানে আছে, caution.
But that's not the
At
case here.
any stage, my lord, after issue of the appointment, a candidate is found ineligible in terms of the advertisement, his or her candidature will be cancelled without any reference to him or her.
That is a standard everywhere. It is there.
In
Nothing.
that, if his lordship takes this analogy, my lord, then in that event, my
There
lord,
is no assessment of her disability. Apart from the assessment done in the district, there is no assessment. There is a general medical examination. A person who has nothing to do with hearing impairment, orthopedic person is sitting in the board, he says 30%, and it becomes
no,
30%.
it has been verified by a
How it can be verified? A report, how it can be
He
verified?
has signed without verifying everything, because everything is based on a test. Suppose, my lord, my PP fasting is 200, my lord. So, my lord, if doctor said, my lord, the doctor it gone on the basis of that medical report, my lord. Fasting 95, PP 200. So I have to, my lord, depend on the on those documents, my lord, and the doctors also, my lord.
Where is the cancellation procedure?
Cancellation of
certificate.
ওই মানে 52 onward subject to correction. Subject to correction in the new.
See, come with the
photocopies.
Yes. You give it to him also?
Yes.
Or get 2 copies of this book from the library. Get the 9 Act and 2016 Act both.
99 rules I have Xerox photocopies.
That you will give on the next.
I shall. And 95 also I have downloaded.
The Learned Counsel for the applicant petitioner has submitted that the tribunal has erred in not interfering with cancellation of the petitioner's candidature in the recruitment process for appointment of LDC. LDC.
Yes, clerkship.
LDC.
Lower division clerk.
Lower divisional clerk in clerkship.
Yes.
Stop. The applicant was a candidate under the category PWD. She possessed a certificate certifying hearing impairment 59%. The certificate of disability was issued by a board of 3 doctors under the medical superintendent cum vice principal and chairman, handicap board, Midnapur College and Hospital. The certificate was issued showing an assessment of the hearing impairment of the petitioner by a board wherein one audiologist was a member. Relying upon this certificate, she participated in the recruitment process and emerged successful. At the time of issuing an appointment letter, the candidates, including the 2017.
I so grateful, my lord.
Get.
Much
Lordship,
obliged.
is that 2 p.m.?
Yes. Grateful. I shall get it xeroxed. Much obliged. And I well, shown that I have read the judgment availed to the Supreme Court.
Let's see,
That is why I
please.
could not place because it
Please.
is not fit for my case. Yes.
124.
Contest the cause. Union of India. Right now we are the required early assessment of the disability.
What method?
Saying this, try to see the practical aspect. She has gone for that. They found her to be suffering with hearing impairment. They thought that it is she will not have any problem. If they have said 50%. It could be. And where the question of some of people losing faith. Possibility that this court out qualify as faith is on the fitness is like certify that she is unfit to the
The 124,
One preliminary
120
submission.
124 and 125, my lord.
That this present writ petition is premature because, my lord, they have come against the interim order and they have not filed any vacating interim order before the learned tribunal, as well as the matter is ready for final hearing and 29/7 is the date for final.
My lord, may I answer to that issue, my lord? My lord, kindly take up the order, my lord. This is a transfer on promotion, my lord. Transfer on page. Transfer of promotion. No, it a page nahi. My lord, here, my lord, there are well, it's six.
So what happened on
Six persons
Yes,
were
my lord.
transferred. My lord.
what happened on 20?
That is the what happened.
What happened on
Yes.
23/6?
That is the order.
23/6, my lord.
They have not filed reply on that date. The matter is
No, in this matter, we have filed the reply.
What happened on 23/6, sir? We are asking you the next.
daily order.
You will keep speaking.
It has been
This
filed, my lord.
this is the way.
Because on the last date, your lordship had told us, my lord. Why haven't you filed the reply? We have filed it.
We don't remember what happened on the last day.
We have filed it.
But on 23/6, what happened?
It has been filed. Reply filed.
No, prior to 23/6 or after 23/6?
After 23/6, my lord.
Then, if you are not interested, then why you are here?
My lord, I am challenging the original order, my lord, of granting a stay in a transfer.
Correct. And you are in this process, you are delaying the proceedings there. So what
No,
is the point in pursuing the
has
matter
not
here?
proceeding has not been stayed. My lord,
It is-
kindly
On
see the facts of-
23/6, you could have appeared and filed a vacating or done anything.
Well,
Unnecessary.
we have in respect of my lord, will kindly give me 2 minutes. This is a transfer come promotion. 6 people have been posted out. 6. All of them have challenged.
We are not on merits.
My lord, we have filed, my lord, the problem, your lordship has asking me this question, why I have not taken steps before the trial.
Correct.
In 2 matters we have taken.
Yes.
Those matters are not being taken up.
So maybe those matters we will interfere. Who knows? If they come before us, we don't know.
Regularly, my lord.
We are talking about this matter.
For the same, this is the same transfer.
We can't presume that the same thing will happen in every case. Can a court proceed like this? You tell us that because in other cases it has happened, therefore it will happen in this case. 23/6 was the date fixed. More than half of July is gone. Because of this matter pending here, nothing is going on in the tribunal.
No, my lord, I
And
don't.
you are saying that.
My lord,
What have you done in the tribunal in the last 2 dates? Tell us.
The reply has been filed, my lord. This is my
We are
submission.
asking you, it is a dispute between employer and employee.
My lord.
There is no question of egos.
No.
So when the issue was already there, why should you jump to the High Court?
Because, my lord, the transfer order, my lord,
unnecessarily
transfer
keep the
order
matter-
has been passed. Transfer has been passed in violation of all settled law, my lord. All settled law.
Transfer order has been passed.
This the stay order on the transfer has been passed in violation of all orders. my
Stay
lord.
is an interim order. It was subject to vacation. You could have filed a vacating petition.
Well,
Who
we
stopped you?
We have filed, my lord. In
When did you
one
file the stay vacating? Tell us.
in not in this matter, my lord, other matters. My lord, kindly understand this. A petitioner goes, my lord, he files a stay petition. That stay petition is not taken up. In the next similar matter, he is obviously not. He knows, my lord, I will file a stay application and nothing will happen. My lord, kindly take up all the matters. My lord, in those matters also will file that let there be early disposal in those matters. Kindly direct us time bound in these 2 matters, my lord.
What time bound? We don't know whether you have filed a vacating petition. We don't know whether you have filed a reply.
We have
before
filed a
20
reply, my lord.
Before 23/6. If you have not shown diligence, then why should we? If you have, then why shouldn't we? We don't know. You are more interested in getting the matter thrashed out in the High Court. That is what we are saying. We are only on that. It may be a very bad order on merits. It may be required to be vacated.
10th July. No, the next date was possibly on 10th July.
So therefore we are saying
রিপ্লাই ফাইল হয়েছে এখান থেকে কোথায় বোঝা যাচ্ছে যে রিপ্লাই ফাইল ও এটা স্ট্যাটাসটা রিপ্লাই হ্যাজ বিন ফাইলড ম্যাডাম এটা স্ট্যাটাসটা না
every matter cannot be decided by us.
10th July 2025.
Same order is not to be interfered with.
Well, in similar cases, concurrent bench has refused them. The tribunal in 2 cases has refused them interim order. Then they came up before this tribunal. Well, kindly understand, this is one in various orders have been passed in.
We are not concerned with any other order than the order before us. We are not concerned.
Then, my lord, let me make a prayer to bring those.
Not at all. Surely not. Why should we?
My lord, kindly.
We are not to substitute ourselves for the tribunal.
Kindly take a holistic view in view of the transfer order. If your lordship was of the view, then set aside the transfer order.
As and when they come, we will see. We are not going to sit here as a super transfer forum and decide whose transfer is correct and wrong. We are on this that why when you come to the High Court and you don't pursue the matter diligently, there should be interfere. That is the only thing. You are not filed a vacating.
My submission is limited to that this stay order should not have been passed.
Obviously, that we have understood.
I cannot make any more submission other than that. Why my lord tribunal, the learned advocate who has been did not file reply on due.
You have to. You are the same person. We don't know an advocate there. You are the same person before the court who is before the tribunal. You can't say you don't know.
Then let's remand it back. I cannot say anything more. I can only submit that this interim order itself is bad in law. And if your lordship does not look into other matters, your lordship has the power. Your lordship can take up all the matters. It is one same transfer order, my lord.
And
concurrent bench has refused stay. Trial court, concurrent bench has refused stay. Two matters in
Who has refused stay?
concurrent bench.
In the tribunal.
Tribunal had refused to stay. They challenged that before a concurrent bench during vacation. The vacation bench did not grant stay of the transfer order.
Every individual has a separate
My lord, in
that cannot be generalized.
These anomalies, your lordship have in one matter there is stay, one matter there is no stay.
Can be.
Your lordship should not allow this.
Cannot be a straitjacket formula for every individual.
Well,
Every individual's claim,
same promotion process, all on transfer under promotion
claim will be different. There can't
that
be
is
a
different.
general claim.
But
That is no ground.
No.
What is the issue? Tell us where he has been transferred. Who is he?
He is a this particular person is a electrical. He has been promoted to electrical high skill 2. The grade is high skill 2. And my lord, he has been transferred from Kalaikonda Air Base to Panagarh Air Base. One of the points which was taken was that his son is possibly studying in the Kendriya Vidyalaya. Panagarh also has a Kendriya Vidyalaya, and as per government policy, any person who is on transfer, my lord, his son or is supposed to be given admission immediately. So that ground does not stand. He has now claimed that he is a member of the union, so he cannot be transferred. Even that ground does not. Rule says that only if he is a member of a particular committee, he will be stayed. He will not be transferred. These are the only grounds, my lord. And my lord, these are both military bases. On last day, your lordship had.
These are civil employments, sir.
Well, these are not civil. These are technical employees. They are used in day-to-day maintenance of the airfields, my lord.
They are not combat personnel.
My lord, airfield, there is no combat person, my lord. Pilot. Other than the pilot, nobody is there to combat. Even the security guard is not there, a combatant. But my lord,
we are not going to go into the merits.
Well, what I am saying
we
is,
are only examining the interim order. We are not going to decide the issue.
Very good. My lord, judgment print for us.
What is the date of transfer? 5/5/25.
Yes, ma'am. Originally, it was transferred. One application was moved. Reason order was passed. Then movement order was passed. এইটা কোথায়? দেখতে পারবে না, বুঝতেই পারবে না, ওই রকম হবে।
What is the next date?
Next date কবে? এই দুটো ম্যাটারে next date 29th July.
You are sure you have filed the?
Yes, my lord. Yes, my lord.
Affidavits have been
Sure.
exchanged.
10/7 they have filed reply, we have received, we have next Monday, we have filed the rejoinder. but-
Already filed.
No, not filed, ready to file. Monday there will be filed.
Monday means what date?
Next Monday, madam.
21st,
21st.
7 is the matter, finally.
So 21st you will file the reply. Tribunal will consider.
Kindly pass a peremptory order that tribunal will consider on that date. My lord, we have reasons to say this, my lord, and all matters.
29th it will be taken up. He is saying by 21st he will file it. But you have not filed a vacating petition. We are asking you.
No, we have not.
Why are you?
We have not. My lord, we in other cases, same matter we have filed. Those are not been taken up. We have mentioned it, it has not been taken up. Mentioned matter. My lord, I'm getting this from the same order, same department, my lord, same transfer order.
You want to file a vacating petition or you don't want to file a vacating?
Well, if it is disposed of, there is no need, my lord. Because vacating of final with vacating application will they will give it an opportunity to file a rejoinder, and these are all reasons why they can seek extension of the time. Well, kindly pass a peremptory order that they should dispose it of. And my lord, kindly not dispose of this matter, keep it pending, my lord.
No,
My humble prayer.
The petitioner before us
most. I should not even said this. That is why I was pointing out to the other matters. How can I keep it pending, my lord? Keep it pending. If it is not taken up, my lord, then
Disposed of. You can always come back.
Next matter also same, my lord.
same OA number will be different.
OA number is
Dates are same.
dates are same. Everything is same. Only name.
Please tell us, otherwise at the time of signing, we will have to verify everything. Tell us right now.
The OA number is different, name is different.
Designation is different.
Designation
Second is,
We have not said designation.
but no, it's not there.
Only OA number.
Only OA number. তুমি অর্ডারটা শুনলে তো? Only difference is OA number. No, other than that, name of the petitioner and
Obvious. That much.
my junior is junior thought it fit to point it out, so I have said it.
Thank you.
Item 126.
Lord, I appear for the petitioner. Lord, your lordship, kindly have a look at the last order. My matter relates to resignation of a doctor. My lord, one show cause was, purported show cause was there, which was placed before the learned tribunal on the date when the matter was taken up. But it was never served upon me. My lord, last occasion, my lord, your lordship passed an order, my lord, on 10th of July 2025, directing my learned senior friend, my lord, to address the my lord, this court, the point of show cause notice issued by the applicant, authorities can withhold my resignation. Although my lord,
The direction has been sought upon it according to the direction of the government. Even though setting this time, I'm not seeing any instruction.
my lord, may I humbly say, my lord, subject lordship, kindly, in your lordship, my lord, in one matter, with lordship sitting with my lord Justice Harish Tandon, my lord, decided this issue, only departmental proceeding pending and a criminal case, or my lord, some dues are there. If these three conditions are not there, and if I fulfill, my lord, more than 5 years, nothing that stops me from, my lord, tendering resignation and moving out. No, but that issue has been well settled by your lordships, my lord, and accepted by them. But, my lord, that is, I have also annexed with this original application.
Director of medical education is under it, because he is a teaching staff. Whether any notice has been served upon him or they are decided to retain him or to release him on forfeiture of the nothing.
He would have been knowing.
No, my lord, as of date,
Has any charge memo or any notice?
nothing, my lord. That is not in dispute, my lord. Nothing has been served upon.
Till date, we are.
Till date, my lord. Today itself, I can say, my lord, nothing has been served.
You find out, tell us on Monday. That is the maximum, because his resignation is pending. Why it should be adjourned unnecessarily?
কালকে কোনোদিন স্যার কিছু
Good, actually,
No, sir, কিছু নেই, sir, আমাকে
when I talk to them around 9 o'clock, they will be in leave the office. They will not leave the office.
No, tomorrow is a working day. Tomorrow is Friday, so we are saying we will take it up on Monday. All right, Tuesday we can do it. If Mr. Mukherjee Learned AGP submits.
He has not completed.
Time we can rise, hardly 10. Till today, plus half. We've got 2 copies. Does it have the 2009 Act? Get the old Act. Old Act. Old Act, 2009. 2009 Act. 8 or 9, yes. All right. Find it.